Hi, my name is Patrick Samasco, an elder law attorney, and I could ask a lot of questions in the office, and I thought I'd like to take an opportunity to answer some of the questions that get asked quite frequently in the office. And this topic today is going to be about estate planning. So the first question that people ask is, what exactly is estate planning? Estate planning is when you want your ducks in a row. You need someone or want someone to be able to make your medical decisions if you should get sick, go to the bank, cash checks, deal with IRAs if you can't do it on your own. And then you want to be able to pass your estate down to your beneficiary as quickly and easily as possible. And you do that with using an estate plan. The next question is, well, do I have an estate plan? I'm married, do I need one? And the answer is absolutely you do. Most common, I know that your wife can sign her husband's name better than he can sign his own. I know that the husband and wives usually make their decisions for you, but if you don't have those formal documents, you don't have an estate plan. If you pass away and you don't have a formal estate plan, very frequently your assets have to go through probate, and then time and money is wasted to get through that probate process. So the next question is, what parts or what are the different elements in the estate plan? And the first one that you absolutely need is a designation of patient advocate or a medical power of attorney. That's a document that you sign that says if you should get sick, you want your husband, your wife, your children, a loved one, or a family friend to be able to make all of your medical decisions. Doctor, hospital, operation, and then decide whether or not you want to be on life support or not if you're terminally ill. I always recommend that you have at least 2 or 3 people in an order to be able to make those decisions. The next document in the estate plan is called a durable power of attorney or a financial power of attorney. That's a document that says that your loved one or whoever that you pick and trust can go to the bank for you and cash checks and deal with the Comcast cable bill or the IRA or sell your house or sell your car. If you don't have those 2 documents, medical power of attorney, financial power of attorney, and you get sick, your family has to go to probate court and have a guardian and a conservator appointed. Very, very important. The next question is, well, hey, I have a will. Doesn't a will avoid probate? And the answer is absolutely not. Wills are designed to go through probate. So if you should pass away and you want your assets to go down to your loved ones, whether it's your wife or your children, and it has to go through the will, it has to go through the probate process, which can take months and months and months, cost thousands of dollars, and everything that goes through probate is going to be a public record. It's time consuming, and in my opinion, it's an absolute waste of time and your hard-earned dollars. So the next question is, well, if a will doesn't avoid probate, what can be done to avoid probate? And that's where a revocable trust is used. A revocable trust, in my analogy, is like glorified will. A trust is a document that says that while you're alive and healthy, you're the boss. If you should get sick, you pick someone to be able to manage your trust affairs, manage your accounts, deal with your bank accounts and your broker accounts and your annuities and your life insurance, anything in the trust, that successor trustee would have authority to manage on your behalf. If you pass away, it identifies who's the beneficiaries. So if you pass away and it goes down to your wife or to your husband and children, that trustee will be there to pay your bills and distribute the money to the appropriate beneficiaries. Now, one of the greatest benefits of a trust is that if you're going to leave money to grandkids, money can do horrible, horrible things to the younger generation. So what you do is you appoint a trustee, again, a family member, a loved one, any other trusted individual that can hold on to that money for those young beneficiaries until they're old enough to manage it on their own. Now, we all know that they're probably not going to be old enough till they're about 65 to manage it. I'd like to recommend, though, that hold on to it to at least they're 25 years old. Before that, the money's available to pay their schooling and buy them a car and help pay their way through college and get through all the hard years. Hopefully they're grown up, get more responsible, and then once they reach that age, if there's any money left over, then they would get it at that time. So an estate plan is a medical power of attorney, a financial power of attorney, a revocable trust, and then a will. And the idea of a will is really a safety net. You want to have all your assets covered by your trust while you're alive or after you pass away. The will is just another way to put assets into your trust. The will says if you pass away, whatever's not in the trust goes into the trust after you pass away. It's called a pour-over will. That would have to go through probate, so you never want to use it. You want your trust fully funded before you get sick and before you pass away. So when you have those 4 documents, medical power of attorney, financial power of attorney, wills, the revocable trust, and all the assets are covered, and that's normally where the problem lies. People don't fund their trust properly. If you do, you have all your bases covered, no probate while you're alive, trusted loved ones to make your decisions for you. If you pass away, the money goes down to the kids or grandkids, held until they're old enough to manage it on their own, and you have a very good estate plan. With the goal in mind that protect you while you're alive and healthy, someone's there if you should get sick, the money and assets go to the kids without any fighting. Because I know the worst thing in the world is that kids fighting, and money can break up families, and we see it every single day. So thanks for listening. My name is Patrick Simasko with Simasko Law. We do estate planning, we do Medicaid planning, we do VA benefits, and I like to call myself wealth preservation. Protect your assets from any conceivable risk out there, whether it's probate, nursing homes, taxes, any other risks out there. We have offices in Mount Clemens, we have offices in Port Huron, we also have offices in Oakland County. So until again, thanks for tuning in. My name is Patrick Simasko.